If you've been following the EU-AI Act and, all the people posting about it on LinkedIn, chances are you came across standards once or twice, or maybe even twice. They're kind of a big deal. And, I'm trying to explain to you why that might be the thing. So what we are talking about when we are talking about EU-AI Act relevant standards. Why EU-AI Act relevant? Well, because while all internationally adopted standards like those from ISO, IEEE, IEC will likely remain relevant and keep on setting the gold standard on everything from medical devices, vehicle safety requirements, and software development processes, in terms of the EU-AI Act, they have to prove their value and aren't a direct demonstration of basically anything. Translated into legal lingo, they aren't harmonized and don't benefit from the presumption of conformity. In contrast to that, harmonized standards, once available, will be usable as a direct means of demonstrating conformity and will benefit from the already mentioned presumption of conformity. And how does a standard then become harmonized? Great question. So first, the Commission issues an official request to the European standardization organizations, meaning CEN and CENELEC, and this was done for a total of 10 AI Act requirements, such as data governance, risk management, human oversight, etc. Check. Number 2, the standardization organizations start working on the standard. How this looks like in practice is that most often CEN and CENELEC kind of cheat a little teeny tiny bit and take most of the things already done by ISO, IEC, and IEEE. Because, standardization organizations are, not even organizations, but processes are painstakingly long and annoying after all, so why start from zero if you don't have to, right? 3, if the Commission is happy with the standards, they reference them in the official journal, and these basically become the law and benefit from the presumption of conformity I was mentioning. Consequences of this successful process: the standards have to be published and made freely available for all. They are the law, after all. Now, as you can imagine, the private standardization organizations from which the EU once took notes in class are usually not particularly happy about this. But hey, great for everyone else. And when does this process fail? Well, 1, if the organizations don't manage to publish a standard at all, or 2, if the EU Commission is not happy with how well the standard would safeguard the rights of EU citizens. In those cases, the standards don't get officially referenced, the presumption of conformity does not apply, and the Commission is supposed to draft codes of conduct for the same provisions for which the standardization process failed. Emphasis on is supposed to, plus the codes might potentially be of even lesser quality, as when the technical people haven't managed to come up with something useful, odds are neither will a bunch of lawyers. But hey, it is what it is, as long as something gets published that helps clarify compliance. Now, if you want to learn more about conformity and its presumption, make sure you tune into our next Spark, where we'll try to break that down.